even in those items we produced today, even a year and a half later, still contain incorrect reporting, claiming that Mr. Harris searched and researched for child deaths in cars. That is not true. It has never been true. The law enforcement has set out and made some statements to suggest that. They have testified under oath to magistrate courts that not only did that happen, but he stated that he did that. But the court's aware, because we've heard it in this very courtroom, he did not state it. He did not do it. And that single piece of incorrect reporting has so greatly affected people, and we've heard it from jurors in this questionnaire as they come and testify, that my goodness, if he's researched how to kill a child in a car, how long it takes for a child to die, that one piece of incorrect reporting, I would suggest, is greatly responsible for a huge amount of improper emotionalism and inability to receive a fair and impartial jury in this case.
Those are the arguments today from the defense trying to get this case moved, trying to get jurors from somewhere other than Cobb County, Georgia. But the bottom line is we really got a sneak peek at where this defense case may be going. I mean, there's an absolute dispute about what Ross Harris was searching or not searching on the computer, what he did, and he pointed to misreporting but also said misled by law enforcement. So you kind of get an idea where the defense is going to go when this trial finally begins. Let me bring in Latonia Hines, who's an attorney and has prosecuted folks up there in Cobb County. Latonia, let's start here with where the defense went there, saying those searches were never done. Do we have a misperception of what this case is all about?
No, I mean, I kind of thought it was a little disingenuous. I guess Brian needed to do what he needed to do, but he's talking about what evidence actually there is in the case and what the jurors or the prospective jurors know based off of the media coverage. I mean, I think that he'll be able to do that once the case actually starts. He can talk about what true evidence there is. And I think it's a little bit, he did what he needed to do, a little grandstanding about it. But the reality is, I mean, much like Judge Staley went over each of the jurors that they'd already qualified and thought were okay, I think that using that is kind of like a last-ditch effort they need to try to be able to make this motion work for them.
Now, Ross Harris in the courtroom today. As always, we've got some video of him. Take a look at what Ross Harris was doing during part of the day today. He wasn't just sitting there idly by watching what was going on. And we'll roll that video in just a second. We're getting it. Oh, we don't have that video. Okay. Well, I'll demonstrate for you what he was doing. He was writing. I was a little surprised. It's like he was taking part in the whole process, taking some notes today during a motions hearing. Darryl, what's that all about?
He's trying to show that he's involved.
To who?
He's not detached.
Who's he showing that to?
He's showing it to those of us who are watching on air, and he's also showing it to the prosecution, and he's showing it, I think it's a preview of the way he is going to act or is supposed to act during the course of his trial. You say act. Charles, do defense attorneys and investigators and consultants ever tell a defendant to just do something even though you're not actually doing anything?
Yeah, sometimes, but I think this is indicative of a defendant who intends on being actively engaged in his own defense. I mean, that's what you would want, ideally, is a defendant who's paying attention, who can even say, hey, listen, what, the testimony you just heard is inconsistent with either something that I said or something that another witness has said. So, whether that's an act or not, that is the conduct that you would want out of
he looks like one of the lawyers. He just doesn't have the jacket on. Okay. Latonia, what are your thoughts about Ross Harris today being seemingly actively involved in what was really a motion hearing?
Well, I think that's good coaching by his attorneys. I mean, you need to show him looking like he's actually involved. Some of the case, he looks a little like he's kind of stunned. He's just sitting there, so it's kind of good to show him actually writing notes, looking like he's involved, that he's invested. Obviously, he should be. He is. It's his life, obviously. So I think it's good to show him actually doing something, and I think that it's a concerted effort because, like we're discussing it, the same people who are going to be in there when they actually finally get a jury selected is going to be watching him. They're going to be watching him every step of this trial.
All right, well, our coverage is continuing. Up next, 11Alive legal analyst Phil Holloway is going to join us from Cobb County. He was inside the courtroom, both sides going back and forth. He knows everybody in this case. We'll get his take next.